So, the Free Speech Union of Canada is a nonpartisan, nonprofit, membership-based organization that is dedicated to the defense of free speech in Canada. We're new to Canada this year, but we work in collaboration with some sister chapters who are a bit more established. You've probably heard of the Free Speech Union in the United Kingdom, which is doing brisk business over there in their little dystopia. We also have chapters in Australia, New Zealand, and South Africa, with a couple more in the wings. There's an International Free Speech Union Association that's incorporated, and we're bringing new countries into our fold over time, and as interest and ability kind of presents itself. So we have, well, I don't want to give any away, but we got two more probably coming on board in the new year. So we in Canada, though, we run separately. We do our own thing here in Canada, and we are taking on and advancing legal cases. We're engaging politically, as we are in this case with these pieces of legislation. We've prepared a brief that we've submitted now to the Justice Committee. We are, even perhaps more importantly, trying to build a community of people across the country who care about free speech and really want to do something about it. And that's one of the beauties of this member-based organization. You're not, if you're participating, if you've joined as a member, you're not just giving a donation. You are coming on board to be a part of this movement to regain our fundamental freedoms in Canada, especially free speech, which we need in order to defend all the others. So I hope you'll join us if you haven't already, and I'll tell you a little bit more about that at the end. But if we don't have widespread support, memberships, and donations, we can't do the work we're doing because we don't get funding from the government, and it's a little bit difficult to get grants when we are not a registered charity. So I hope you'll help us out and let us do the work that we're hoping to do. And one of those things we want to do is help educate people on things like this that are coming up on our radar that might be infringing free speech, clearly are in this case, and that we all need to probably speak up about and do something about before it gets passed. So I'd like to introduce my co-panelists tonight. Bruce Pardy is a professor of law at Queen's University and a senior fellow with the Fraser Institute. He's executive director of Rights Probe and has taught at various law schools across Canada, the United States, and New Zealand. And he's on the board of the Free Speech Union of Canada. He's a bit of a national treasure at the moment, in high demand, as he speaks all over the country about various constitutional issues, and we're delighted that he made time for us tonight. Hannah Park-Roche she graduated from the Peter Allard School of Law at UBC in 2020, and served as a judicial clerk at the BC Court of Appeal before taking a position with a Vancouver law firm. She's currently working for her family business, though, and making lots of time for us at the Free Speech Union. She's on the board, and she's doing all kinds of great work in the background, helping with writing briefs and running our social media channels. And it's been a delight to have her on the team. Colin May, who is a lawyer in Calgary, is our research director, and he was going to join us tonight, but unfortunately, he's out of the country at the moment, and his internet connection was very unstable, so he wasn't able to join. So tonight, what we're just going to do is we're going to have a bit of an informal chat amongst the three of us about the various provisions, and I'm going to put them on the screen. It's weird to me having this format. I don't actually see the participants. I just see my screen with the PowerPoint, and so it's making me feel a little weird, and I'm talking funny, but hopefully I'll settle into it. So we had people submit questions in advance because we knew we were going to have a big turnout, and unfortunately that makes things maybe a little less chatty amongst the whole group, but that's what we thought might work best for tonight. And there is a chat function which is available to you. So if you have a further question and we have time to get to it, then Mary Beth, who is on our events team, volunteers for us. She's handily working the waiting room and the chat line, so she will let us know if some other questions come in. But if you're craving some more personal interaction with the Free Speech Union team and your fellow Canadians who care about free speech, we have another event coming up in November. It's on the 27th in Toronto. We are having an event called the War on Science with our chair, Lawrence Krauss, who's a theoretical physicist, and he's written a book called The War on Science with essays from various academics across actually the Anglosphere, including Bruce, who will be one of our guests, and a few others who will be there, including John Kay and Dr. Kulvinder Gill, um, uh, Francis Widdowson, and Jeff Horseman, who are also professors who have written for Lawrence's book. So hopefully it'll come out on the 27th. Tickets will go on sale tomorrow, and for members, they'll get an advance opportunity to purchase on the member portal. All right, all that business aside, we need to talk a little bit about Bill C9, and we're going to get to Bill C8 a little bit at the end, but C9 seems to be the one that's the most pressing from our perspective. Before we get to the meat of those two bills, though, we know that this isn't the liberal government's first foray into trying to regulate speech, and so there was something called Bill C63, which died on the order paper of the last election when the last election was called, and a previous version had died previously when another election was called. We might have yet another election, and so maybe this one will fall by the wayside too. But we have to prepare nonetheless. So this particular bill, Bill C9, seems quite a lot more focused than C63. And so I was wondering if either Bruce or Hannah, and we're just going to have an informal chat here, so just chime in if you have some thoughts. If you have any thoughts on why the government has introduced this particular version and what it means for their efforts to regulate Canadian speech.
Go ahead, Hannah.
I was going to say the same.
Oh, sure.
I mean, I'll just start by saying I think one of the reasons Bill C63 came under such fire was because it loaded so many things into it. And one of the big bits of feedback that people had was you can't, there seems to be a Trojan horse of sorts because there's so much wrapped into it. And so I think one of the reasons they focused it just into hate, where they basically took a bunch of the hate related provisions, changed some of it, kept some of it, and packed it into this neat little, much shorter, like 10% of the length of what Bill C63 was, but only about hate. But they did make some concerning changes, and they even more concerning than Bill C63 was initially. And so I think that's probably why we're seeing it in this form. I don't know if Bruce, you have, I'm sure, something to.
No, that makes sense to me. Bill 63 was widely condemned, at least in certain quarters, and it was a terrible bill.
Terrible.
It basically consisted of three parts, and the one part of C9, which is what we have now, was the C63, like C9, proposed to make amendments to the criminal code, and that's the part of C63 they've taken out and put into C9. So there are other things that were in C63, like amendments to the Canadian Human Rights Code, which were very problematic and may have had an even more severe effect upon speech than the criminal code provisions. Those are not in C9. The Liberals seem to have prepared the ground to bring C63 back. It'll have a new number, of course, but the rest of the substance of C63 may yet resurface in yet another bill. But for now, C9 is the criminal code part of this.
All right. Well, let's give everybody a little bit of a perspective on what exactly is being amended here, because this bill, as you can see on your screen, is there's some changes to the criminal code, but it's really kind of hard to understand what Bill C9 is all about without kind of looking at it in the context of the other provisions that it's amending. So I just want to quickly paint a bit of a picture of what we have. I mean, first of all, there's already hate speech provisions in the criminal code. So this is not new, but they're adding some important changes to it and making some other changes which are quite problematic. Section 319 of the criminal code already criminalizes something called the public incitement of hatred. So everyone who makes statements in a public place that could incite hatred against any identifiable group, where that's likely to lead to a breach of the peace, is guilty of an offense. And then it goes on to say anyone who, by communicating statements other than in private conversation, willfully promotes hatred against any identifiable group is guilty of an offense. There's another section on anti-Semitism, which criminalizes public statements condoning, denying, or downplaying the Holocaust. Okay? So that's already there. Now, Bill C9 adds an offense of willfully promoting hatred against any identifiable group by displaying in any public place certain symbols, which we'll discuss shortly. There's some defenses in that section as well for the willful promotion of hatred offenses, and that includes proving that the statement's true, made in good faith, based on religious text, relevant to a subject of public interest. And those offenses might help you if you're, just kind of, you have a legitimate reason for saying the things that that you've said. But the problem is, by the time you're getting to raising defenses, you've already gone through the process of being arrested and charged and, had your life upended. So it's all well and good to say there's defenses, but they come in at a later stage of the process. So what there wasn't in 319 before was a definition of hatred. Okay, so the courts had sort of worked that out in various cases that came before them, some famous Supreme Court of Canada cases like Keegstra and Whatcott. And now Bill C9 purports to codify that definition and put it right into the criminal code. Okay, so I'm going to that's just a little bit of background, and our other panelists can elaborate on that. But what Bill C9 adds is this definition here that says hatred means the emotion that involves detestation or vilification and that is stronger than disdain or dislike. Now, there's all kinds of words in there that are subject to interpretation, as you can imagine. There's another provision there that says that for greater certainty, the communication of a statement does not incite or promote hatred only because it discredits, humiliates, hurts, or offends. Okay, again, a lot of very subjective words, which I'll let our other speakers get into a little bit more. So, so we have the courts giving us a definition of hatred, and now this is something that is a little bit different. Can you tell us how it's different and how or if that is significant? Bruce, I'll start with you.
Sure. Yes. So Stephen asked a really good question in the chat. And the question is, since these bills are blatantly unconstitutional, how is it possible for them to receive royal assent? And that question is important because it underlines the beginning problem. And the beginning problem is that these bills are not blatantly unconstitutional. They ought to be. And if you just read the very sort of blanket guarantee in the Charter of Rights, it simply says freedom of expression. But the problem is that the Supreme Court of Canada has already said, and said long ago, that censoring speech for this thing that we were calling hate speech is in fact a reasonable limit on freedom of expression. And this definition in C9, hatred, means the emotion that involves detestation or vilification and that is stronger than disdain or dislike. That definition has been lifted out of a Supreme Court of Canada decision that uses those words. And it's designed to look as though what Parliament is doing is simply lifting out the definition that the Supreme Court gave so as to make it clearly constitutional, not unconstitutional, but constitutional. Now, in doing that, what they've actually done is watered down what the Supreme Court said. Now, what the Supreme Court said was bad enough. And frankly, for my money, is not at all clear and does not draw a clear line and goes further than it ought to. But even so, this bill goes further by taking words out. So just to give you one sort of obvious example, they talk about the Supreme Court talks about detestation and vilification. They've taken out and put in or. And well, you say, well, what's the big deal? Well, the big deal is that the Supreme Court is discussing a threshold. And in order to be convicted of hate speech, you need to be shown to have spoken beyond the threshold. And so the effect of this definition is to lower the threshold and make it more possible for someone to be found guilty of this offense. Just to put into relief the vagueness of this definition, it involves detestation or vilification, and it is stronger than disdain or dislike. Well, it may be obvious, I hope, to everybody that, where the line is between those two things is not clear at all. But if you look at the definition of detestation, I mean, what does it mean to detest? You just look it up in the dictionary. The definition will include an indication that detestation means intense dislike. Okay, so now you have a definition that says it's criminal to intensely dislike, but it's not criminal to dislike. So where is the line between intensely dislike and dislike? Well, nobody's going to know that. And it's going to be left to the court in any particular case to decide whether or not what you've done consists of intensely dislike as opposed to just dislike. And that means that you're going to have a chill on free speech, and you're going to be subject to the systemic uncertainty of the law. No one's going to know exactly where the line is going to be drawn, and therefore, you dare not speak out too much, too close to the threshold.
And just to add to that, in terms of lowering this threshold that already is not good, goes against your actual right to freedom of expression. The codified definition says, anything that involves detestation or vilification, whereas the Supreme Court talked about something that was clearly associated with.
Right.
So, and there's other things, they describe not just an emotion, as you can see on the screen, it says hatred means the emotion. The Supreme Court of Canada talks about it as the emotion of an intense and extreme nature. So they've removed words. They've kind of played around with it. They've lowered this already low threshold for your right to speak. And it's extremely unclear why they needed to do that, since in every case where you have a hate crime or any of these hate propaganda offenses are prosecuted, they're pulling that definition straight from what the court has said anyway. So it's not even clear why they needed to lower this threshold. And so it does come back to what Bruce was saying about, in answer to that question, well, it really comes down to the problem that this isn't blatantly unconstitutional anymore. So
yeah, and one thing I might add too. So just notice here what it is that the criminal code is now essentially calling out of bounds. So traditionally, a criminal offense consists of usually two elements: an act and an intent. An actus reus and a mens rea. You did the act and you did it intentionally. That makes sense because you're punishing guilty behavior. Fine. What this definition is doing, and what the hate speech provision essentially is doing, and you'll note this in the definition, it is now criminalizing an emotion, not an act, not an intent, an emotion. Hatred means the emotion that involves yada yada yada. Okay, it is now criminal to experience an emotion if that emotion is the thing that is motivating you to speak or to act. So we're now into dangerous territory where the criminal law is now supervising the emotion that people feel when they're committing these acts.
And in case you take heart at the fact that there's some sort of clarification provision, don't take too much heart, because for two reasons. One, that it's not very clear. Unlike Bill C-63, this is kind of a weird difference, but Bill C-9, the clarification doesn't seem to necessarily apply to every time hatred comes up. So that's a little confusing. So it's not really clear when when they give that for greater certainty provision comes up. But more importantly, when the Supreme Court of Canada talks about it, they clarify it themselves, but they don't say solely because it discredits, humiliates, which is here what Parliament is limiting it to, just solely. In the Supreme Court of Canada actually says something that goes far beyond discrediting, humiliating, or offending. So even the clarification itself has been supremely watered down from what the court has said. And so in both directions, you're going away from a robust protection of freedom of expression.
And I suppose you could say that they've used that phrase for greater certainty. I mean, they must mean that ironically, because there's no certainty to be found.
If I were a cynic, I would think that they deliberately put a definition in, knowing that there was one that was well established in the jurisprudence, in order to cast the net wider. I mean, I think that's the only conclusion.
Oh, I think that's fair. I think that's definitely fair. Sure. Absolutely. Yeah.
And then you have to think, like, the average person who is going about their lives not intending to be a hateful person, not intending but wants to engage in debate on controversial topics, now has to think twice about whether they're going to cross some line. And so I'll even just give you a practical example. And I don't know if there's anybody here from Laurier who was at the event there a week or two ago, where there was a debate on gender identity. And prior to the event, the one of the people who was participating said, "I think you should check your potential remarks against the hate speech laws and the human rights codes, and make sure you're not going to cross any lines." It's kind of a veiled threat, like, you're going to get in trouble if you say things that are discriminatory or constitute hate. And I helped prepare a participation agreement, basically, up front, so that everybody agreed to come and have a debate on gender identity without the threat of legal proceedings following. And who knows, maybe there will be, maybe there won't. But that's exactly how this kind of thing gets used. And the wider the net gets cast, the more likely this becomes now a chilling threat that people can say, well, that's hate speech. And now you can't have a conversation about the impact of gender identity on women's sex-based rights, which is one of the topics somebody mentioned in the chat, the UK, and our free speech union in the UK has done a brisk business representing women who are getting in trouble for discussing gender identity and women's rights. So you can see how this is very problematic. Even if you're someone who is not going out and saying death to whoever, you're not a violent or evil person, but you might be impacted by this nonetheless, because something might be important to you that you want to talk about, and somebody else is going to say, well, hey, that's I'm an identifiable group, and we'll talk about that in a second too. But that's something that is it sounds like you're detesting and vilifying me. So anyway, there's other real world examples. Can you think of any others, either of you?
Oh, well, I mean, Lisa, your list of cases raises all kinds of great examples of situations where people have said, fairly obviously true things and got in trouble with all kinds of different authorities. You're also a gender thing. I mean, your Amy Ham case was a great example. Not under this legislation, or not under the criminal code. I mean, this is the thing. The criminal code is the most extreme version of this kind of punishment, but there are lots of other venues for getting yourself into trouble, like with respect to Amy, under the auspices of her professional regulator, or obviously, for a complaint to the Human Rights Tribunal. And not limited to that, you could get yourself in trouble, from a school board or from a university. So the criminal provisions we're talking about here are essentially at the top of the heap as far as it goes with censoring speech. They historically have been rarely used, and the other kinds of things that I just mentioned are much more frequent. Nevertheless, even if you have it on the books, you now establish sort of a new norm for what constitutes criminal activity, and that will no doubt have a chilling effect upon speech.
Hannah, any thoughts?
Nope. I think it's been said.
Okay. Well, I mean, it's certainly possible that this could become a bit of a cudgel, where, people say, if people say things like words are violence now, and everything is considered hateful and harmful. So I do think this will open up another front, that it won't be quite so rare anymore. I think probably with most of the hate cases that we've had to date, most people would look at them and say, yeah, that was pretty bad. They shouldn't have said that. A lot of people will say that. But the problem with not defending or drawing the line at an earlier point when the speech really is detestable is that once you decide that you're going to just start calling everything hate, you just keep expanding. The line keeps moving, and nobody really knows where it is, because it is involving an emotion, like Bruce said. So it's a very difficult thing to define. It's like one of those things where we'll know it if we see it. And that's not a way to run a criminal justice system. So I'm going to just I think the free speech union's position generally, I mean, I don't speak for every single person involved in it, but we've had some conversations, and I think generally we fall in along the lines of we really shouldn't be criminalizing speech at all, except in very, very clear cases of incitement to violence or threats, which is already criminal. Violence, real violence is where, not just words of violence, but real violence is where the line needs to be drawn into criminality. So we would take the position that this bill should be withdrawn, but in the interest of trying to help the committee, in our brief that we submitted, we did put in a few recommendations, and one of them is with respect to this, which was just to tighten up that definition so that it does bring back the more rigorous test that's in the Supreme Court of Canada legislation, so that it is stronger than disdain, get rid of the involving stuff, and that must be interpreted as being restricted to those extreme manifestations of the emotion described by those words. I don't know whether anyone will listen, but we're making some recommendations nonetheless. The next change to the bill, change to the criminal code because of this bill, it has to do with the removal of Attorney General oversight. And I just wanted to give you guys a bit of a background on that as well, so you know why this is important and what it's changing. It sort of sneaks it in quietly in a couple of lines, but when you look at what sections they're repealing, one of them is to repeal section 318.3. Now, there are no other changes to this section that I recall. This is the advocating genocide provision, but they've taken out the requirement for the Attorney General to approve the institution of proceedings. So basically what that means is the police can't just go and charge and then lay a charge and then it just gets into the system and everything, just goes along. The Attorney General has to approve the laying of the charge and the institution of proceedings. So that puts a high level oversight into this process and makes sure that it's not being done sort of without reaching that threshold. Okay, so that part of the legislation we haven't really talked about in this bill, but they removed it there too. But the one that we were talking about, that's 319, the willful promotion of hatred offense and the willful promotion of anti-Semitism. Both of those sections used to require the Attorney General to approve proceedings. That is now being removed by this bill. So, for my part, I would just say that I think about the United Kingdom and the police going around to people's houses and saying, "You've said something on that's not so good." Are we going to end up like that as well, where the police now have incredible discretion then, and nobody is overseeing when these hate charges are being laid? I know that our counterparts in the United Kingdom, one of the members of the Free Speech Union there is a former constable, and he has said that policing's changed over the last couple of decades. A lot of them now, at least in the United Kingdom, and I'm not speaking for here, they're well trained in critical theory and social justice, and some of them have agendas, and so they have an enormous amount of power. So I don't know what your thoughts are in comparing us to the United Kingdom, Hannah or Bruce, or just on that removal generally. But go ahead and give me your thoughts.
Go ahead.
Well, I think just my general thought on this is that it does push us closer to that. It provides the police with an extraordinary discretion to lay charges. And the critical part here is that laying a charge has a really large impact on the life of a person. Even if that charge doesn't end up going anywhere, you could get arrested, you get slapped with all these bail conditions, which can affect where you can go, at what time you can go, not to mention any sort of reputational damage and lost wages and et cetera. So like it matters. It matters that we're laying more charges, and not just from a court budget perspective, which it's also bad for. It's bad for just general taxpayer dollars. But it's providing too much discretion to police, and it's going to result in a lot, like an unrecognizable pattern of charges, more in some areas, less in some areas, just depending on the police and depending on how they feel, depending on their own particular biases and what they think is a hate motivated offense and what they don't think is a hate motivated offense. Because that's why we wanted to go over the definition of hatred at the outset, to just put into perspective how everything depends on an incredibly subjective, wide, broad, all-encompassing definition of an emotion. And then now you're giving police all across in different jurisdictions the authority to lay charges based on what they consider might be an emotion. And if they're unsure, they might just lay one just in case, because then you can later drop charges. And so it actually is quite dangerous. It can result in arbitrariness. It can result in complete a differential application across jurisdictions, which is really not what you're looking for when you're trying to operate in a democracy that is built on certainty and clarity and people knowing what is legal and what's not. So that's the
Right.
biggest problem I see here.
Right. Right. I'll just add that for my money, 319.2 there that you see on the screen could be the most dangerous provision in the criminal code. If you combine it with the new definition of hatred, and individual police have the discretion to lay that charge, nobody knows what's going to happen when you speak in a negative way about some group. You might be fine, and you might not. And as Hannah says, if you get charged, you get a whole lot of grief, even if you're innocent. So there's a whole lot of trouble there.
And that answers some questions that I think were sent in ahead of time or that someone has just recently sent into the chat about. Are you allowed to hate someone who's harmed your family? If they're part of an identifiable group and you say something here, that is a willful promotion of hatred against them. No, I would say, you're not legally allowed to do that, and so it does affect your ability to live your life, have your emotions, and leave the morality out of the, this particular morality of whether or not you should have this emotion out of the criminal code. And so, yeah, I agree with Bruce. It is absolutely so incredibly dangerous when you combine all these and then you combine the new sentencing provisions and all that good stuff.
Yeah, let's talk about identifiable group for a minute. That was the next slide anyway. So two of the new offenses that are proposed are against identifiable groups, and that's already in the criminal code, right? But now we're adding willfully promoting hatred against any identifiable group by displaying certain symbols and impeding access to certain places used by an identifiable group. So what is an identifiable group? They do give you a definition of that in the code. It was already there. That is the one that relates to the offenses we were just looking at before, the existing criminal code offenses. But so it's any section of the public distinguished by color, race, religion, national or ethnic origin, age, sex, sexual orientation, gender identity or expression, or mental or physical disability. Okay, so now you have to willfully promote hatred against them. But as we've talked about, that's potentially a very broad net. And so what I guess the question that I would have on this topic about identifiable groups is, are we seeing that all groups that are identifiable are equally treated?
And of course, the answer to that is no, right? Because you can see the pattern elsewhere as well, right? You can see it in the human rights jurisprudence. You can see it in the charter. Exactly, yes. So it looks as though, I mean, this is worded as Section 15.1 of the Charter is worded. It looks like it is prohibiting hatred against any of those groups on any of those bases. But actually, what it really means is, what's going to mean in application is that you're not allowed to speak badly about what they are considering, as they say in the Charter, a historically disadvantaged group. Right. Which means, essentially, to be blunt, that means, depending upon the circumstances, of course, it generally means anybody but white, straight, Christian males, and maybe also including other groups like women, especially white Christian women. But it depends upon who, what the case involves, who spoke and who was it about. But I would find it very surprising if anybody was ever charged under this section for saying things like, white people are settlers, or white people are supreme, or all of that rubbish. And they shouldn't be. To be clear, I'm not saying that they should. That should be free speech. But by the same token, the equivalent kind of criticism we just don't know whether some policeman on some occasion is going to say, you know, you can't say that about that group. And that's the danger that's being set up.
Right. And so just because we have now lived through the last decade and we understand now, many of us, most of us probably have been forced to kind of come to terms with things like critical theory, which look at the world through an oppression lens. And if you are of a particular group, you are an oppressor, and another group is oppressed, and that lens gets applied to a lot of things. And so, will it get applied here to determine whether charges should be laid in some cases or not others? I think my sense certainly is that we're already seeing it. I mean, we're seeing it with the protests that are happening. Some protests get the Emergencies Act brought upon them, and others go on and on and on. I'm being a little jokey, but not really. I mean, I don't know how many charges have been laid in relation to some of these protests we've seen over the last couple of years. I'm not suggesting that they should be getting charged, but I'm just saying maybe there's a difference, and maybe that's what we're going to see on steroids now as more and more things come in that are based on group identity. Any thoughts on that?
No, agreed.
Yeah,
for sure.
Yep.
Yep.
Okay. All right. Well, let's
continue.
Sorry.
I was just saying, I think the same pattern will continue. There's absolutely no reason to think it won't.
Right. All right. So let's move on then to the hate symbols.
But
so
before we go on, Lisa, Murray's asked an interesting question. Maybe we'll just refer to that just for a sec.
Okay.
He's asking
Sure.
whether or not a
Yeah.
carefully constructed test case is possible in which some brave soul plans and says something publicly and repeatedly, which is clearly an offense under the bill, but inherently creates a good constitutional argument for the higher courts. You know, is that a possibility? Well, sure, of course. And I would hope that if this became law, that might be a plan. Like, let's all go out and say things which might fall within the definition of the act and dare the authorities to charge and prosecute. That might work. I'm not sure, though, that they wouldn't sidestep that to avoid that kind of confrontation and outcome, even for the very reason that it will be obvious that we're trying to incite them to charge us and go through that process. I suspect that, well, there are all kinds of other things that have come up over time. Like there's a private member's bill, I think, right now in BC that proposes to make residential school denialism a crime. I'm not sure if that's a BC member in the federal parliament, or is it federal? Okay, that's good. That makes sense.
Federal. I was just looking at it, Bruce, and it's very similar to the anti-Semitism provision that's in here. She's looking to add another passage on residential school denialism. But for downplaying, not denying, but downplaying. So basically, I don't think it'll pass because it is a private member's bill, but nonetheless.
Right. But see, that just occurs to me as, so this is vague enough so that the authorities could just say, well, that doesn't reach the threshold. But that one we're talking about, this private member's bill about residential school denialism, is specific enough. So if that one happened to see the light of day and get through, that's the bill that I would like to see everybody say, you've made criminal denying, these details about residential schools, right? I am saying for the record, I am denying for the record these specific things that you have in your bill. Come and get me. That's what J.K. Rowling did. I was just going to point.
I was just going to point that out. She did that for Scotland, didn't she? They brought in, and I don't remember the specifics well enough to tell the story. Maybe someone else did, but it was sort of a hate kind of offense that she basically, in relating to gender identity, which is her thing,
right?
And she taunted them and basically invited them to come get her, and they backed down on that, didn't they?
Yeah, they did. Yeah, and that's the proper response to that kind of outrageous law.
Yeah.
Yes. So steel your spines, folks. Maybe this is what we'll have to do at some point too. All right. So let's talk a bit about the hate symbols, because this is the new thing that's come in now, and it's up there on the screen. It's a lot of words, but basically, it's important to understand this context too, because I've listened to a few other presentations on this, and I know people are worried about like anything getting on the list. But there is a process that's, if again, you have to sort of look at all the sections that they reference together and understand what they're trying to do here. So in order for a symbol to be something that you might get charged over, it has to be related to a listed entity, which is on their terrorism list. And there's other definitions for that. And I'll take you to another screen here in a second. So the only ones they specifically reference are the Nazi swastika or the SS bolts. And then they sort of add to the potential confusion by saying a symbol that resembles one listed above could also be possibly considered a hate symbol. So, and then those are offenses that you could go to jail for up to 2 years for that one. So, but let me take you to the next screen and just show you the terror list. Okay, so this is where they get their list of hate symbols. So it has to be related to a listed entity, and the list is established by cabinet on recommendation of the Minister of Public Safety and Emergency Preparedness. And there's a test. They have to have attempted to carry out, participated, or facilitated a terrorist activity, or acted in association. So there is a little bit of an extra bit of, criteria. It's not just random things that they're going to put on the list. However, when you think about, there's a huge long list of terror organizations. Most Canadians wouldn't have the first clue who's on that list, what symbols they have, if they even have a symbol. And you might carry a flag at a protest thinking that it was perfectly legitimate, then find out that, oh, actually there's some lettering on it that makes it related to a particular group or what have you. So there's certainly some potential there, I think, for that net to be a little bit too wide as well. There's also no requirement that the symbol itself be notorious or solely connected to a designated terrorist group. So one of the things that I was thinking about recently was the St. George's flag in the United Kingdom, which is the flag of England. It's got history as representing England as a country before it was part of the United Kingdom, I guess. Making that up, maybe. But what we're seeing now is it's kind of been adopted by some nationalist groups, okay? And they may be anti-immigration or anti-mass immigration. And so now it's becoming a bit distasteful to the point where authorities are taking down the St. George's flag and people are going around putting them up. Is that the kind of symbol that was a perfectly legitimate thing before, but is now being adopted by a group that might find itself on a terror list at some point that you now cannot use? I mean, that's where I see this kind of thing going, is that list is not fixed, and things may find their way onto it that are not historically hateful. I mean, again, we don't like that word, but yeah, what are you guys worried about with this one?
Well, I think what you said is perfectly valid. I agree with it. I think it's a slippery slope. I think all the trouble that you mentioned is possible, but my objection is more fundamental. I don't think any of these symbols should be outlawed. I mean, in Germany, as you might expect, Nazi symbolism is outlawed. And because it is, there are all kinds of people who use the symbol to mean a certain thing. Like I've heard about people writing books with that on the front who are trying to make the case that somebody in the government is acting like a Nazi. And they're prosecuted, presumably because they've used the symbol and somebody is interpreting their use of it as not what the message was at all. But it becomes a weapon in the hands of the authorities who want to use it to suppress the speech they don't like. Now, what's the rationale for allowing people to use all these terrible symbols that represent awful things? The point is that you're allowed to show the world that you are either dangerous or stupid. I mean, if you are an adherent to these ideas of one of these groups, I mean, don't we all want to know that that's where you're coming from? I mean, if you want to plant the flag of one of these groups, that's a really good indication that you're a dangerous person. I don't think that any of these things should be prohibited because we have free speech, not because anybody should approve of them, but because we disapprove of them. And we want to know when people are doing disapproving kind of things, we want to know who they are.
That's right. It does tend to drive things underground.
Mhm.
There are some defenses to this too, by the way. So, I mean, again, defenses come into play after you've been charged. There are exceptions for legitimate purposes like journalism, religion, education, or art. Those are things they specify, but that's a certain amount of discretion. We'll go into which charge, whether charges should be laid, whether it's a good enough excuse, whether it was art that was meant to be provocative versus art that was meant to be hateful. I mean, who's going to decide that? Are the cops going to understand that? Hannah, do you have some thoughts on this?
I think building off what Bruce's fundamental problem with the whole thing is, which I agree with, it's an extremely, again, it's a political process, not a democratic one to this whole list about what even qualifies. There's lack of transparency over how you get to this list. But I think Bruce nailed it on the head when he talked about the fundamental problem that you should be able to wield these symbols as you want. That's just part of free expression, and I do think it will drive things underground. I think there's so much benefit to being able to like look out in the world and see who you agree with and who you don't agree with, and yet what we're doing with this whole law, the theme that we'll keep coming back to is not just, oh, I'm afraid of, I will go to jail. It's more likely that you will just not say the thing. You will just not wear the flag. You just won't, like, it's just a universal chill on what people will do. And then suddenly you're living in a world in which you can't trust that anyone you're interacting with is honest in any kind of way, which is a very, very scary world to live in because everyone's afraid of the same thing, of whatever legal repercussions legislation like Bill C9 threatens to usher in. So that's really the concern, is that it's just another chill, it's just another way of chilling another form of speech, which is symbols. Yeah. There's
Right.
no clarity around how you'd prosecute that anyway.
Yeah.
The Hindu, the swastikas actually come from Sanskrit, and it's a Hindu religious symbol. And so, I think you see groups, they'll jump onto the defenses and say, yes, this needs to be in a defense, and yes, we need to figure out how we won't be captured. Hindu groups saying we won't be captured under this legislation, which is good. Yes, you again, it's good to have those defenses, but you're just like, the train has left the station at that point, and you need to be a lot more concerned about the fact that you should never have to worry about this in the first place.
Yeah,
Hindu or
and that's right. You actually, Hannah, when we were doing the brief, gave a little example too of how symbols that some people value can't, and I sort of touched on it before with the flags, but you used the example of the Star of David. Do you want to share that thought? Because I thought that was clever.
Well, I think my thought was just that the way in which symbols that are so highly valued and precious on an emotional level to groups can be wielded as can be flipped around, and obviously we saw that during Nazi Germany, and the Star of David became a way to brand people, a forcible branding using a symbol, and again, that's like a form of compelled speech. Like if the inability to wield any symbol that is on this list for any reason is a removal of your right of free expression. Well, compelled speech of any kind, whether that's through a symbol or words, is also itself an infringement of your right to free expression. And so the symbol thing can also get twisted around, and before you know it, you're looking at
Yeah,
just
yeah.
horrific use of a symbol that is precious to certain folks.
Well, once again, we don't want this. We're telling them, please get rid of this entirely. But at a minimum, it's cleaning up the language so that it's not just promoting, but inciting hatred, and that is expressly listed so people know what the heck they're dealing with. At a minimum, I mean, I don't even, on some level, we don't even want to be making recommendations just because we don't want to be seen to be approving of the rest of it. That's not the intent in any way, but it's just on the assumption that it may go forward. At least it gives a little bit of hopefully correctiveness to it. But Anyway, so that is the symbols. And now I'm just going to move on to the next thing. There's a lot to cover in this
Sorry,
bill.
Lisa, I just wanted to say I've noticed a couple questions about the constitutionality of the bill, and how the fact that the government has to provide these charter opinions, which I believe they've done for both Bill C8 and C9, and they found for both of them the potential to engage your rights, which they usually do. They usually find, okay, yes, there's a potential to engage your Section 2B rights, and then but we saved it under Section 1. We found that it's actually a justifiable limit of your, if we did engage it, then we found it as a justifiable limit. So we can drop some links in the chat, but you basically just look up Charter Analysis Bill C8 or Charter Analysis Bill C9, and you will see the government analysis. I'm pretty sure they have released one on both of those sometime in
If they
October.
have,
So
they're very thin. They
yeah, they're
basically come
extreme.
to the conclusion that everything's just fine. So
Yeah, let's add as well that the real test of constitutionality will be when this goes to a court, and in particular the Supreme Court. And as I mentioned at the beginning, the Supreme Court has given us this problem by decisions it has made in the past. Even so, we've also suggested that the threshold here has been moved down, making it easier to get into this territory compared to what the Supreme Court said. But our friend Ryan Alford, who's a prof at Lakehead, made the point during his testimony in front of the committee, and I think it's quite right. He said, one problem is that if this goes to today's Supreme Court, I mean, the Supreme Court we're talking about is 2012. If this goes in front of today's Supreme Court, even if this bill fiddles with the threshold and moves it down, it might be, given the makeup of today's Supreme Court, that this Supreme Court will again change the goalposts and say, oh, well, yeah, it's not quite what was described before, but it's fine. Why? Well, because this Supreme Court could very well be more sympathetic to a greater degree of censorship than even the 2012 version of the court. So constitutionality depends entirely upon what the court does.
yeah.
And that's very hard to predict, but it's at least a good shot that this court at this moment may not say that any of this is an unreasonable limit on free speech.
And
Yes.
and we're getting looser and looser on the it's more about how much can we justify infringements rather than how robustly can we protect the right. That's really the approach of the courts these days. I mean, Lisa experienced this even recently, kind of got sneered at by an appellate judge when she began to talk about freedom of expression. And so, and it's not to say to be hopeless. I don't think anyone would be here if we were hopeless, but just to be realistic about the state of the courts. Okay, sorry, Lisa, continue.
Yeah, no, it's a fair point. We've seen some decisions recently that have been a little bit alarming. The Ward decision, which was a few years back now, which was a slim 5-4. That's with the comedian who was mocking somebody who was disabled. And then there was fairly recently, and it's a different kind of case. It's defamation, but the Hansman and Neufeld case gives me a little bit of concern as well to see what the court did there, which is basically endorse this idea of counter speech. So something is not, you're not committing defamation against somebody who's speaking evil of say, for example, in this case, transgender people, and it wasn't evil, I'm being facetious, but it was criticizing BC's curriculum, basically, SOGI curriculum that's out there for gender identity in schools. A trustee was critical of it. He then was, in his view, defamed by somebody who from the union, the teacher union, so he sued him for defamation, but he lost at the Supreme Court of Canada because the teacher was engaging in counter speech to defend a group that was marginalized and needed that sort of protection. So when you see the kind of language in the Supreme Court's decisions already, you're going to know where that's likely to go. So, any more thoughts on that one before we move on? Okay, so standalone hate crime. Now, this is so before, and I'm not a criminal lawyer, so I just say that with a little bit of a take this with a little bit of a grain of salt. But my understanding was that hate came into play during sentencing previously, and I suppose it still could. But now there's an extra. It's much more explicit with this standalone hate crime, and so now, if you commit an offense of some kind, and it doesn't even just have to be under the criminal code. It says here under this act, being the criminal code, or any other act of parliament. So any federal piece of legislation, and there are things that are called offenses in other kinds of legislation as well. It's not just criminal. If the commission of the offense is motivated by hatred against an identifiable group, then you get an extra penalty. Okay, so you're guilty of an offense separately over and above whatever the other one is. So if you're found guilty of, so there's maximum penalties depending on what the included offense is worth. So the more serious the underlying offense, the greater the additional penalty. Am I saying that right, guys? You can chime in here if
That's correct.
I'm not.
Yes, but note how the penalties work, right? So if you commit an offense under some other, well, even under the criminal code, but let's say some other federal act, could be a regulatory act, some kind of administrative offense, which does carry a penalty. It's an indictable offense, nevertheless, but not a criminal code offense. See, if the offense you've committed carries a maximum term of 2 years, but they say, and it's established that you did it with hate, now you're guilty of a second offense of 5 years. So they're really like doing more than doubling down. And this is a good example of a situation where this is explicitly punishing just the feeling of hatred, right? Yeah. When you're doing hate speech, at least you have to speak. That's the act, accompanied by the emotion of hatred. But in this case, it's some other offense, and then they add a new offense which just consists of the emotion of hatred. That's all.
Now, there's other emotions out there that are not very nice to have. So, for example, greed, retribution. Sometimes we even, put it in quotes, honor societies will commit crimes to defend honor, which can be pretty horrible too. So, but it's not hate. So, why is this particular emotion treated differently than other negative emotions that might motivate somebody? I guess what I'm trying to say is if you had an offense, let's just say an assault that was motivated by greed versus one that was motivated by hate, both aren't very nice motivations, but only one of them is going to get extra penalty, right?
And that brings up the more fundamental point, which is this. Let's just use that as an example. Let's say you have somebody committing an assault. They commit it for hate. They commit it for greed. They commit it because they don't care. Which of those three things is worse? If you assault somebody randomly on the street because you're a psychopath and don't care, is that better or worse than if you attack somebody because you hate them? For my money, that's irrelevant. The crime is in the violence. But that idea has now been done away with.
And it's been done away with on a massive scale because it now converts non-criminal offenses into criminal offenses just by the feeling of hatred.
That's right.
So it takes everything that is an offense under a federal act of parliament, and it's now possibly criminal if you've done it with a certain emotion. And the other thing that's kind of, Lisa sort of hinted at this at the beginning, but so hatred is an aggravating factor on sentencing. So once you've been convicted of the offense of assault, for example, the judge, before they sentence you, has to, under the criminal code, if you've done this motivated by bias or hatred, they have to take that into account, and that will likely increase your sentence. What Bill C9 hasn't done is in any way modify that. So you could actually get kind of duplicated, like a duplicated punishment, because you could both do it motivated by hatred, and now you're charged under different provisions, and this provision pretty much doubles most of the minimum penalties or maximum penalties, sorry. And then it could also still be used as an aggravating factor on sentencing because Bill C9 has not done anything to say, well, then you don't then go and use it as an aggravating factor. So it's just extremely harsh and additional liability in addition to absolutely blowing open they're just making a lot of things criminal that aren't currently criminal just because you do them with a certain emotion.
Right.
Just as we're talking, I'm trying to think of acts that are not criminal pieces, not the criminal code, but that have offenses. And it occurred to me, I'm just checking to see if the Canada Human Rights Code describes offenses under its code too. But I mean, there's the possibilities could be endless here of.
Oh, they are endless. So even a statute like the Competition Act has offenses in it. They're called offenses. They're not criminal code offenses.
Yeah.
And from memory, I don't remember if they carry a prison term. They really shouldn't. They're regulatory offenses, but they are offenses. And so technically speaking, you'd think that they would fit under that first part of the definition of this.
Well, I was thinking too about federal family law acts. I know certain parts of family law are provincial, and so those wouldn't be covered, but Divorce Act, something like
Sure.
that. I'm not sure if that has offenses under it. You basically have to go and look at all the federal statutes, look at the offenses, and if it's possible to do it with an emotion, which I'm sure it would be, then now that's a criminal offense rather than something under a specific statute.
Right. All right. Let's move on.
So while we have a moment, there's a couple of questions that maybe I could just refer to. One was, will this be retroactive? And this is one of the few moments when we can give you some good news. Technically speaking, it should not be retroactive because it's criminal law, and there is a section of the charter which appears to prohibit retroactive effect of laws. The Supreme Court has said that applies to criminal code offenses. So we should be okay in that regard. If everything goes the way it looks right now, unless the Supreme Court changes the goalposts, it should not be retroactive, but effective from the time that it's enacted. One more question. Is saying you don't agree with veiled women now a hate speech? If saying you agree with countries that have banned face coverings, are you now guilty of a hate crime? And the answer is, we don't know. I mean, you wouldn't have thought so, but given the material, it's impossible to say with certainty that's going to be okay. This is essentially the problem.
All right. It's already 8 o'clock, just after 8. So again, recommendation, get rid of it all. Get rid of it. But at very least, get rid of this any other act of parliament. I mean, what the heck is that? It just casts this ridiculously broad net. So that was what we put in our brief. All right. Then we're on to obstruction and intimidation, which is these are this is in relation to buildings that are used for religious worship, or you can see that the section goes on to define something that's used by an identifiable group for other purposes. So might have a school or a daycare center, residence, but they have to be used by an identifiable group. Okay, and a cemetery is another one as well. And now we're criminalizing anybody who obstructs or interferes with their access. And there's a little carve out for, I assume that would protect journalists from who are maybe going to see a protest or something from being caught up in that net. But let me just go back to the top. This is engaging in any conduct with the intent to provoke a state of fear in a person in order to impede their access. We already have some legislation out there about intimidation and other things that could probably mischief, things that could capture this kind of conduct. But now we've added in another flavor, which is this intent to provoke a state of fear. So it does seem to add another. So you're not only looking at your own intent to provoke, but it does seem to suggest that you now have to question the state of fear or in emotion in another person for this offense. What are your thoughts on that? Is this requiring now an assessment of a potential victim's emotional state as well?
Sure. Let's make something very clear. probably not talking about a situation where you engage in some conduct, whether it's words or actions, that threaten violence. Because we already have that as a criminal code offense. That's called an assault. That is already covered. So this must be something else. And the something else is conduct that you engage in with the intent to provoke a state of fear of what? And the answer is, well, it's not violence because that's covered. A state of fear of, and this is a reflection of where we're at ideologically, right? A state of fear of, as the convoy was accused of doing, creating a state of fear of an ideological perspective that is harmful. So we're on very shaky ground here. It's conduct that you have the intent to provoke some kind of a state of fear in somebody else. And so we are again into the realm of criminalizing emotions that have nothing to do with violence.
And to make it extremely clear in terms of, Bruce had mentioned earlier that when you have a crime, you have the act and the mental intent. And the act here is any conduct. So in
Any conduct.
100% of cases, your actus reus has been met. And all the
Correct.
court will examine is your mental intent. So the entire conduct part of the criminal law process, which is a huge part of a trial or anything like that, is done away with because 100% of people will be found guilty of any conduct. And so you are looking solely at the mental state. And remember, in the laying of this charge, it's the police now because you don't have that AG oversight when you're relating to some of these offenses. Although actually, I don't know if that one applies to this, so I might have spoken out of turn there. But you're dealing with a totally different fear standard. It's not fear of violence, like Bruce said. It's just fear in general. And when you're looking in the context of a protest, what could be disruptive, and protests are meant to be disruptive, that's the whole point, could be read by some as evidence. If you're disrupting, that could be evidence of your intent to instill fear in other people. And so in my view, the prosecuting of this is quite an easy process, or will be quite a seamless process. For prosecutors, it'll be easy to lay charges. And sorry, just the last thing I wanted to mention was that these spaces are for identifiable groups, but a lot of groups have actually written in and said, well, it's spaces that are occupied by identifiable groups, but they're not necessarily identifiable spaces themselves. Like just because we actually could convert tens of thousands of spaces that are innocuous and most people don't know what they are, they could be captured under this provision because you're not aware that is a space that is used or occupied by an identifiable group for administrative purposes or other purposes. And so it really captures a really large variety of conduct in a huge variety of places without people actually being aware of those places being what they are.
Right. All right. We've added some suggested language, threatening conduct and fear of violence, but again, it just all needs to go. It just needs to go. I mean, other groups, I did listen to a seminar by the Center for Israel and Jewish Affairs, and they were actually pleased with this because they felt that it was a bit of a token. At very least, it was a sort of a recognition of some of the hardships that the Jewish community has gone through with various protests at some of the synagogues and facilities and educational, schools and what have you. I get that on some level. I sympathize, but this is just the tools are already in place to deal with problems at these places already, and I don't think that they're being used at this point anyway. So there's already sort of selective enforcement and potentially double standards. But what it does do is when they do decide that they want to go after somebody, they've given them a lot more ability to do so successfully.
Yeah, and that's one of the signs of a tyrannical situation, right? If you have a society in which there are all kinds of laws about all kinds of things that are all sitting on the shelf not being used, and the authorities have the discretion to take one off the shelf when and if they want to, then you don't have a rule of law. because all of those laws are not being applied until somebody in particular says, you know what, let's get that guy. We have a law, let's pull it off and use it. So you don't know what the law is until the discretion is exercised to get the conduct that they want to crush.
Right.
And
All
just to
right.
answer a couple of questions in the chat just on that point are really good. One was about a library or classroom being used for a drag queen story hour. I think that's a good question.
Yeah.
Yeah.
I think the provision right now covers whether something's being primarily used by this identifiable group. So it would really depend on if the group is like the space is primarily used by them and if they're the ones then hosting it. And I don't know how this can be twisted and turned so that would be captured. But the next, sorry, before you speak on that, Bruce,
Yeah. Yeah.
the next one as well is relevant. So maybe you can speak to both of them as well. The union
Sure.
strikes and picket lines, because
Yeah.
I think this could be covered where people are actually ironically outside their own places. They know it's used by a specific group. They're protesting their own something or other, whether that's a union or something else, and they're captured by this provision. So I think those are both really good questions. And Bruce, I'd like to hear what you have to say about them.
Well, so the drag queen story hour is very intriguing, right? So if it's an educational institution of some kind, let's say a school or a library, and that's not regularly used for that purpose, but it's being used for that purpose today, and everybody knows it, and that's why they're there, and that's what the signs in the picket lines say, the protest, and the event is being, advertised as drag queen story hour, and the people on the sidewalk are saying, don't go listen to this drag queen tell your kids a story. Sure, it's possible. I mean, you could fit that inside this bucket if you were an authority and you decided that was an evil that you wanted to crush. There's lots of room for that.
On that cheery note, it's already 8:15. I was only hoping to go till 8:30. And we also promised something on Bill C8. Now, it is a massive bill. We're only going to touch on very, very briefly. It's a massive bill. It's probably mostly, I mean, I'm not a telecommunications expert. I think we probably want to protect our cyber security. But there's some things in here that are concerning, and we just want to draw them to your attention. Um, and one of the problems is just the overbreadth of how it's drafted. Again, it's unfortunate. Those of us of a certain age probably kind of grew up just sort of blithely going along and trusting that your government wasn't necessarily going to do anything that was terribly against your interest. We don't really have that confidence anymore. A lot of us who've kind of been observing this for a while, and so when we see that things like the Emergencies Act declaration or imposition happen to a protest, or that bank accounts are frozen, or different things happen like that, we really have to learn to look carefully at every single piece of legislation now and see how could this be used against ordinary Canadians who are just kind of going about their lives, or I mean, again, sometimes you're not going to be caught in the net unless you go a little bit to the edge, but that edge is not clear. So this one too has a concerning provision, and we'll just take it to that. It's mainly in this section here, 15.2, where essentially great power is being given to a minister of the government, the Minister of Public Safety and Emergency Preparedness. Oh, sorry, sorry, that's not they do it in consultation with that minister, but they have to come to the conclusion that it's necessary for the security of the telecommunications system against any threat. They don't specify the kind of threat or the level of severity of that threat, and then they are able to get an order prohibiting a telecommunications, or will make an order prohibiting a telecommunications service provider from providing any service to any person. So basically cutting off your internet if you are that person. Now, I did listen to some of the committee discussions that weren't in camera, just to kind of get a sense of how their own experts are talking about this. And they're saying, really the purpose of this bill is the protection of systems. It's really not intended to be applied to the speech of individuals. Our scope is set as being kind of just for the system generally, and that they're just kind of saying, well, that's not what our what do they call it, our scope statement of scope is including. But again, the language of the law is different. Any threat may result in any service being denied to any person. So, any reason to be concerned about this, or is this a nothing burger?
Oh, it's not a nothing burger. It is, as you say, it's a very broad discretion. And note that this does not describe an offense. You don't have to have committed an offense for this to happen. This just the minister has the power to make an order just because they think that there's a threat that you might pose to the system. And then combined with the other part of this bill, which I think is equally disturbing, that order can be made so that it cannot be disclosed. Both the contents and its very existence cannot be disclosed. So you can be cut off for some reason that the minister thinks that you pose a threat, and you can't figure out why. And they won't tell you. They won't tell you what the order exists. They won't tell you what it says. They won't tell you how to fix it. This is an extreme degree of power held within the bureaucracy to do as they think fit.
And it comes with serious penalties if you don't follow it. Like, what does it say? 25,000 for your first offense, 50,000 for your second for an individual, and then for companies, huge 10 million for the first contravention and 15 for every subsequent. So there was a question in the chat about Starlink. I'm assuming it would apply to anything like Starlink as well, telecommunications provider. But you know that now we're kind of getting into some air law stuff. I'm not really sure. I would imagine, Bruce and Lisa, maybe you have a better idea, but I would imagine it would. And if they don't oblige, then they're going to start getting slapped with 10 million the first time, 15 million the subsequent
Oh, I
time.
imagine they would do their best to do that. The question is whether or not Starlink is too big to be concerned about what the Canadian government might do. But
Yeah.
as a matter of jurisdiction,
I think they could do it.
it's
Try.
being provided in Canada, so the Canadian law should apply. Yeah.
Yeah.
It was interesting to listen to the fellow from I think I don't know what his role was specifically, but in the committee hearings, he was obviously the person who was informing the MPs on what the purpose of the law was. So I assume he's a bureaucrat with some responsibility in this department. But what he was saying was, that this seemed to be more applicable to entities as opposed to individuals. He said, people aren't going to be coming after individual speech. But they don't say entity, they say anyone. And here they have a fine against, oops, I lost it again. Oopsie. Oh, sorry about that, guys. Okay, you can see we're close to the end. But they talk about fines for individuals here too. So
Yeah.
the provisions are there for an individual to be fined. That isn't necessarily an entity. They didn't use that word.
Yeah.
Yeah.
So it
So
seems like you yourself can't disclose the existence of that order. And which is you have the right to free expression. And so that itself seems like a big problem to me.
So the question from Josephine, who says, is one of these orders judicially reviewable? Can you go to a court and say, would you please review the order? And I think the simple answer is yes, except that when a court does review an order, it's reviewing whether or not the order is consistent with the statute. That's the test. Has this authority exceeded the authority that the statute gives? So if the statute says you can make this order and you can make the order secret, then the likelihood that the court will overturn the order is very small.
Extremely small because it's
Right.
so discretionary.
right. And deference is given in these kinds of cases. So
Right. So,
yes, so there, I think they could judicially review it, but it would be to little effect. So yes, this is a concerning one too. It's a massive bill, but this particular one seems to, from our perspective as free speech advocates, this is the one that concerns us the most. So before we there's a couple of questions that came in advance, and I'm going to touch on those. I also want to just touch on action items a little bit as well for what people can do. Obviously, writing to your MP, if you've got a conservative MP who's opposed to it already, write to them anyway, because look, I did a presentation at a committee 5 years ago and had a whole bunch of conservatives who were in agreement. And that bill died on the order paper because of an election as well, I think. And then we ended up, then they voted unanimously in favor of it at the next go round. And so don't assume, put pressure on them anyway. And you can write your own letter. I'm hoping to get a template up on our website that can be used as well. Check back, give me 24 hours to check back again. I'd like to have something up there that can help guide people on that a little bit. But certainly, you know, you do want to speak out as much as you possibly can on it. They do listen to, well, they're politicians, right? That they want to know what their electorate is thinking. So be loud and vocal about it. And you can write not just your MP, but also with respect to C9, write to the Attorney General. You can also copy the members of the committee. You can find that on the government. I'll try and make this easy for you by putting some stuff on the website to direct you a little bit if you'd like, but you can do your own thing as well. Other things that you can do, you know, we're really at the threshold here of a very, I think, fairly dark version of Canada. Maybe we've crossed it already. Maybe actually, I think we've crossed it. Can we pull back in time? Is the door closing? It's closing. You can probably still get back through it. But my goodness, we need to do stuff. And so one of the purposes of the Free Speech Union is, and having people come on as members, is that, you know, we're going to work together. We're going to find ways together to change the culture and shift the culture. I mean, we can't. I'm not one to give up, and so you know, we got to keep fighting. And so one thing you can do, if you're not a member, please join. Tell a friend. Go tell another 2 or 3 friends to join. We can't do any of this if we don't have members. We don't have the credibility, which we're starting to build as we're still very new, but we want to be able to say to the government, we represent thousands of Canadians, tens of thousands of Canadians, and be a voice for effective change in this country. And also just to have good people working for us that can help with cases and can help with you know, running this organization. We need all the help we can get, and we won't be able to do it. Honestly, we won't be able to do it if we don't have people step up to help us. We want to do more things to build community as well. As I mentioned at the outset, we're having an in-person event in Toronto. Those who don't know as much about us, we have had events in Hamilton and Vancouver. We're trying to do that as often as we can to get people together. We also are unveiling a member forum so that people can come in, not just to whine about the state of the world. I mean, we all want to do that too, but this needs to be about action. We need to be moving the needle. And so we want people who are action oriented coming in and coordinating, getting organized, doing things that actually help to push things in the right direction again. So I hope that you're inspired to join with us and to be part of this movement. There are a few questions that came in advance, and some of them are about free speech unions, so I'll take those. Do you defend independent media? Well, I think freedom of the press certainly falls under Section 2B of the Charter, which, while we're not charter bound, that is the section that we focus on. So yes. Do these bills or other hate speech provisions mean that we might not be able to criticize certain religions or ideologies without being accused of a hate crime? I think we touched on that. Probably the short answer, well, criticize. Okay, can we criticize? Bruce, you want to tell people if they can criticize?
The folks who are putting this bill forward are going to say, well, of course you can criticize a religion. That's not intended to curb that kind of dialogue. But when it actually is in place and when the police have the discretion to decide whether or not you're causing a problem, then all of those statements are basically out the window, and we're left with the text of the provision, and the answer is, who knows?
And just go back to what Bruce said at the beginning, like, is this dislike or is this intensely dislike?
Right. Yes.
How is the FSUC prioritizing which cases to take on, and perhaps relatedly, but from a different person, what steps is the FSUC taking to make sure it's not seen as politically partisan? All right, well, first of all, I will say that we aren't politically partisan. However, lately, in the last decade or so, we've seen a lot of the free speech encroachment coming from the political left, which has been in power. And so, of course, we're going to end up seeming to be defending more cases on that are falling into what is now called the political right, although frankly these labels are becoming meaningless. So it's not that we're seeking to do that actively. It's those are the kinds of cases that come across our desk, and we haven't taken on a ton yet. We have a few. We've had 3 or 4 because we've written some letters of concern. We want to take on more, but we need resources to do that, and so we will take on as many as we can that fit within our mandate. But subject to our having the ability to do it. We've got to be able to pay people to take these cases on. We are getting our mailing list more active now. We had to warm it. There's a big list of people on our that we have, and so it's taking some time to start getting regular newsletters. But you will get them, and you will get pitches about these cases, and hopefully you can help fund some of them.
Sorry, just to add to that part, because I do
If I
think
go,
that, sorry, Lisa, I just wanted to add to the nonpartisan part because at the both at the teams level, for example, our communications team or at the board level, we have so many discussions about different things that come up both on a media, just on like a social media level, or when it comes to more taking on cases. And we really, first of all, we have various opinions on the board, especially, but we really try to bounce things around to get ideas to try and pull from all sides of the aisle when it comes to the cases. What we're quite, I think at this point because we're small, we are very intentional about trying to do that. The current atmosphere is making it difficult for us to appear as nonpartisan as we feel we are. But we are trying, and we try at the board level especially to talk about these things, about different cases that come up or different, maybe they are not our personal cases, but cases in the news. And sometimes we have to reach out across the globe and take some cases from overseas in order to show some, it is really not a right or left issue, even though right now it kind of really looks like it.
and we have, by the way, an excellent team of volunteers, and I see quite a few now that I've gotten rid of my screen and I'm able to see more than just the PowerPoint. Quite a few of our volunteers are in the meeting as well, and I just want to say thank you so much to everyone who is making a contribution, whether large or small, helping with the website, helping with making those great cartoons we put out, helping with social media and newsletters and planning events and just all kinds of things, keeping track of all the members and the databases, which is a huge, ridiculous job. But anyways, we're getting there. We're new this year, but we are. I think we're going to make some great strides, and we've got some wonderful people helping us, and we're happy to find ways to fit more into our fold. There's a couple more questions, but then I do want to wrap up. One is there a way to attack C9 by causing the more heinous aspects to be split off? I honestly don't know how we would do that, other than making some recommendations about certain things that shouldn't be part of the bill. But I don't know that there's. I think the whole thing needs to go. Frankly, I'm not. It's hard to decide which things are more heinous. If you could wave your magic wand, Bruce? Which things would you get rid of?
Oh man, I don't know. I agree that the whole thing really has to go. It's very difficult to try and take it apart and leave something there that is palatable. But to the larger question, this is very much a product of political machinations, and it's difficult to see in the parry and thrust of Parliament how this is going to be defeated unless the Liberal government gets on the wrong side of public opinion. And I don't see any sign of that on this bill just yet.
All right. One more. Are these bills made as broad as possible so the government can go in any direction and target anyone with anything at any time?
Yes,
Yeah.
yes, yes, essentially. Yeah. Right.
Yeah.
But that's not just with respect to these two bills. I mean, this is there's a pattern here, and more our governments are trying to become the word that I've seen used is agile. Agile governments, meaning that they think they need to have the control to react promptly to some kind of perceived problem, and to do that they need a very wide degree of discretion to act, and therefore the statutes that empower them try to do that. They try to give a very broad mandate, a very broad grant of power, so that they can act and not get caught up. And that's one of the problems with the state of law that we're in, where we are losing the idea of the rule of law and instead are being ruled by law. That is, the law is becoming a tool on the part of the executive branch of government to do as it thinks best.
Well, on that cheery note, thank you. I'm sorry you're all just names on the screen. We weren't trying to be, I don't know, cold or whatever, but we do want to meet you all in person if we haven't already. And so please join us and watch out for events. And as I mentioned at the outset, we've got one coming up at the end of November, the 27th in Toronto. So if you're in that area, please come out and let's see you in person. And there's people who I know are on the West Coast. We've been out there. We'll be back. East Coast, and we'll get there eventually. And once we get this member forum a little bit more active as well, you can start planning some events too and have some meetups with people who might share your concerns in your own part of the country. So thank you very much for coming tonight. We appreciate all the support. It's lovely that you spent some time with us tonight, and let's fight for freedom.
Thanks for coming, folks. Good night.
Thank you.
Good night.
Good night.